expressly stated otherwise. This was a very cautious approach.
Presumed irrevocable. Wow.
Yeah, but this has largely changed. In most modern jurisdictions, and certainly under the widely adopted Uniform Trust Code, UTC, a trust is now presumed to be irrevocable unless the trust documents explicitly state it's irrevocable.
Okay, so the presumption flipped.
It did. It reflects a modern preference for flexibility.
That's a significant shift in legal presumption. So if an essay question doesn't specify, I should discuss both rules, but lean towards applying the modern one. That sounds like a common trap for students.
That's a fantastic strategy for your essays, absolutely. Acknowledge the traditional rule, but then transition to applying the modern UTC rule in your analysis, unless the jurisdiction explicitly adheres to the old rule or the facts clearly indicate otherwise.
Okay, good tip.
As for how a settlor can amend or revoke a revocable trust, they can do so by substantially complying with a method provided in the trust's terms.
Follow the instructions in the document.
Right. For example, if Eleanor Sterling's living trust for Liam states, this trust may be amended by a signed and notarized instrument delivered to the trustee, she must follow that. If the trust doesn't specify a method,
Then what?
then it can be amended or revoked by a later will or codicil that expressly refers to the trust or specifically devises property that would have passed under the trust. Or, crucially, by any other method that manifests clear and convincing evidence of the settler's intent to revoke or amend.
So even if it's not done formally, if the intent is super clear.
If the intent is clear and convincing, yes. This last point provides a safety net for less formal revocations.
What if there are multiple settlers? For instance, if Eleanor and her husband, Robert, created a joint trust, does one person's decision affect the whole trust, or do they both have to agree?
Good question. That depends on the nature of the property held within the trust. If the trust contains community property assets acquired during marriage in certain states like California or Texas,
Right, community property states.
then either spouse can revoke the trust alone regarding their half, but they can only amend it by joint action. This reflects the co-equal ownership principles. However, for non-community property, like separate property each brought into the marriage, each settler may revoke or amend the trust only with regard to the portion of the trust property attributable to that settler's individual contribution.
So you track whose money is whose.
Essentially, yes. When a revocable trust is revoked, the trustee must deliver the trust property as the settler directs. However, a trustee is generally protected from liability if they acted in good faith, genuinely believing the trust hadn't been amended or revoked. This protects the trustee from, being caught blindsided.
So trustees have a bit of a safe harbor if they're not aware of a change. Makes sense. Beyond active revocation, can a trust just automatically terminate without anyone doing anything specific?
Yes, absolutely. A trust terminates to the extent that it's revoked or simply expires according to its own stated terms.
Like ends when the kids turn 30.
Exactly. If the Sterling Family Trust states, this trust shall terminate when the youngest grandchild reaches age 30, it automatically ends then. It also automatically terminates if no purpose of the trust remains to be achieved, if all the goals have been met or are no longer relevant.
Or if the purpose becomes impossible.
Right. If the purposes of the trust have become unlawful, contrary to public policy, or impossible to achieve, for example, if the specific educational institution the trust was meant to fund ceases to exist, it can terminate. However, and this is important, a trustee can often block premature termination by beneficiaries if the trust is still serving some material purpose.
Material purpose? Like what?
Like a discretionary trust, a support trust, or an age-dependent trust where the beneficiary hasn't reached the specified age yet. The law values upholding the settler's original ongoing intent if there's still a good reason for the trust structure to exist.
Okay. What about non-charitable irrevocable trusts? These sound much harder to change, almost set in stone.
They are, by their very definition, far more rigid. A non-charitable irrevocable trust can be terminated or modified by the consent of all beneficiaries.
All of them?
All of them. But only if one of two conditions is met. Either its continuance is not necessary to achieve any remaining material purpose of the trust.
Here's that phrase again, material purpose?
Or the proposed modification is not inconsistent with a material purpose. This is the crucial threshold.
Material purpose sounds like it could be quite broad and subjective. How do courts generally define what constitutes a material purpose? Because that's what's going to make or break a modification attempt by the beneficiaries, right?
You're right. Identifying a material purpose is often the central issue in these cases. While not an exhaustive list, there are common examples that strongly indicate a material purpose still exists, making modification or termination by beneficiaries alone more difficult.
Okay, like what?
Well, a spendthrift provision, which we discussed, is often considered a material purpose because it aims to protect the beneficiary. However, in some jurisdictions, this alone might not be enough if everyone agrees.
What else?
A discretionary distribution provision, where the trustee has ongoing, active discretion over payments. That suggests the settler wanted that specific management structure to persist. A support provision, similarly keyed to the beneficiary's needs. A postponement of enjoyment provision, for instance, delaying principal until age 25 or 30. The settler's purpose is often maturity, and early termination would frustrate that.
Right, don't give the 20-year-old the whole pot.
Exactly. And the existence of future interests, like remainders to unborn children or shifting executory interests, often suggests an ongoing purpose to protect those future rights.
So if the Sterling Family Trust says principal to Liam when he turns 30, and Liam's 25, that's a material purpose of postponement. He and the other beneficiaries can't just agree to end it early and give him the money now.
Yes. Unless the settler, Eleanor, is also alive and consents. If a modification or termination is inconsistent with a material purpose, it's generally not permitted unless the settler also consents. With the settler's consent, meaning Eleanor is alive and agrees, even if inconsistent with a material purpose, and with all beneficiaries consenting, it can be modified or terminated.
So the settler's agreement overrides the material purpose.
Effectively, yes, if all beneficiaries also agree. The trustees doesn't technically need to consent, but any party settler, trustee, or beneficiary can commence a court proceeding for approval or disapproval. If terminated by consent, the trustee distributes the property as the beneficiaries agree.
What if the settler is dead? Can an irrevocable trust still be modified then, or is it truly set in stone once the creator is gone?
No, even post-death, an irrevocable trust can still be modified in specific situations. First, if all beneficiaries agree to a modification that is consistent with the material purpose of the trust. This might involve minor administrative changes.
Okay, consistent changes are easier.
Right. Second, and this is a common scenario to flag in your notes for exams, if an unforeseen event has frustrated the original purpose of the trust.
Unforeseen event. Like what?
Like if Eleanor created a trust to send her grandchildren to a specific university that then closed down, or if a grandchild develops a severe, unforeseen medical condition requiring extensive funds not initially budgeted for. When you encounter a fact pattern with unforeseen events, be very clear in your analysis about what the specific purpose of the trust was and how the event frustrates it.
Got it. Focus on the purpose and the frustration.
And remember, a trustee cannot unilaterally terminate or modify a trust. It almost always requires court intervention or beneficiary settler action.
Are there any other ways trusts can be modified or terminated? What if something totally unexpected happens, or the trust just becomes unmanageable or too small?
Yes, courts have inherent equitable powers to ensure trusts remain functional. A court may judicially modify, reform, or terminate a trust due to unanticipated circumstances, or if the trustee is simply unable to manage the trust effectively. Also, if the trust becomes uneconomic.
Uneconomic, like the fees are eating it up?
Exactly. If the value of the trust property is too low to justify the cost of administration, a court can modify or terminate it to avoid wasting assets on fees. Courts can also reform the terms of a trust to correct mistakes of fact or law, or modify them to achieve the settler's tax objectives, even if beneficiary consent isn't required, though parties usually seek court approval.
So the court acts as a kind of safety net or problem solver for trusts that have become outdated or inefficient.
Exactly. Additionally, a trustee may combine or divide trusts after giving notice to beneficiaries, as long as it doesn't impair any beneficiary's rights or adversely affect the trust purposes. For example, consolidating several small, similar trusts into one larger, more efficiently managed trust.
Okay, combining trusts.
And finally, regarding revocation by divorce. Traditionally, a spousal interest created by a trust was not automatically revoked upon divorce, unlike a provision in a will.
Oh, that's a tricky difference.
It was. However, the current trend, and in many jurisdictions the law, is to treat a former spouse's interest under a trust similarly to one under a will. This means a former spouse is treated as having disclaimed their trust interest upon divorce.
So divorce often automatically knocks the ex-spouse out of the trust now.
In many places, yes. It brings welcome consistency across estate planning documents and reflects modern marital property law.
Okay, once a trust is up and running, All that careful planning hinges on how it's actually managed day to day. That responsibility falls squarely on the trustee, who holds a tremendous amount of power and, well, trust. What are their main responsibilities, and how do they interact with outside parties? It feels like they have to be part financial wizard, part diplomat, and part legal expert, all rolled into one.
You're absolutely right. The trustee holds immense responsibility and is indeed a fiduciary, which is the highest standard of care recognized by law. Before any duties are formally imposed, though, the trustee must formally accept the trusteeship.
They have to agree to do it.
Yes, they can accept expressly or just by starting to act as trustee. Once accepted, they are charged with safeguarding the trust property and acting as a fiduciary, meaning they must always put the beneficiary's interests first above their own.
Always beneficiaries first.
Always. A trustee has the powers necessary to act as a reasonably prudent person would in managing their own property. This includes implied powers to contract, sell, lease, or transfer trust property, even if not explicitly listed in the trust document, as long as it's for the trust's benefit.
So they have broad operational powers to manage the property, but they have to be incredibly careful not to abuse them. What about third parties dealing with a trustee, say someone buying a property from the trust? Can those third parties be held liable if something goes wrong with the trustee's actions?
Yes, potentially. A third party can be held liable if they participate in a breach of trust. Therefore, third parties must act in good faith and provide valuable consideration when dealing with trustees.
Good faith and fair value.
Right, meaning they pay fair market value and there are no suspicious circumstances. However, they are generally not liable if they act without actual knowledge that the trustee's action constitutes a breach of trust.
So if they didn't know the trustee was doing something wrong.
Exactly. If a third party genuinely doesn't know the trustee is acting improperly, for instance, Sterling Bank and Trust is selling a trust property way below market value due to some internal issue the buyer isn't aware of, they are usually protected unless they had clear reason to suspect impropriety.
Okay.
Now, let's get into the absolute heart of trustee responsibilities. Their core fiduciary duties, these are paramount. The overarching duties are the duty of loyalty and good faith and the duty of prudence.
Good faith and prudence. Those sound like common sense principles, but what do they specifically mean in the context of a trustee, where people's livelihoods and legacies are at stake? This must be a higher standard than just being a decent person.
It absolutely is. The duty of loyalty and good faith means the trustee must administer the trust in good faith. That's a subjective standard, meaning they genuinely believe they're acting correctly and act reasonably when investing property and managing the trust, always in the best interests of the beneficiaries, which is an objective standard.
Subjective good faith and objective reasonableness.
Both. On any legal exam, it's critical to determine both. Good faith alone is not enough. The action must also be objectively reasonable and for the beneficiary's benefit. You can't be well-intentioned, but incompetent, basically.
Right.
A truly critical aspect of the duty of loyalty is avoiding self-dealing.
Self-dealing. That sounds bad.
It is. This is when a trustee personally engages in a transaction involving trust property, creating an inherent conflict of interest. The law takes this very, very seriously. The following are generally prohibited transactions because they present an irreconcilable conflict. Buying or selling trust assets to themselves, even at fair market value.
Even if it's a fair price.
Even then. Selling property from one trust they manage to another trust they manage, unless explicitly authorized and totally transparent. Borrowing from or lending to the trust. Using trust assets to secure a personal loan. Or engaging in prohibited transactions with close friends or relatives. Basically anything where the trustee acts for any personal gain, direct or indirect, through their position.
So even if Sterling Bank and Trust found a fantastic deal for the Sterling Family Trust, but it involved selling an asset to one of its own senior executives, it's still a no-go, even if it seems like a win-win for the trust.
Exactly. When self-dealing is at issue, there is an irrebuttable presumption that the trustee breached the duty of loyalty. This is a per se breach.
Per se, meaning automatic.
Automatic breach. No further inquiry into the trustee's reasonableness, good faith, or even whether the trust actually benefited is needed. The act itself is the breach. This isn't just a legal nicety. It reflects the law's deep suspicion of conflicts of interest. The potential for abuse is just seen as too high.
Wow, okay. That's strict.
It is. Even if self-dealing is somehow authorized by the settlor, a court order, or all beneficiaries, the transaction must still be reasonable and fair to the trust to avoid liability for breach. Now, if an alleged conflict of interest arises that cannot be characterized as self-dealing, meaning it's not one of those directly prohibited transactions but still potentially problematic, then that conflict is assessed under the more flexible, reasonable, and in good faith standard.
Okay, so self-dealing is automatic breach.
Mhm.
Other conflicts are judged on reasonableness.
Got it.
What about the duty of prudence?
Right, the duty of prudence. Modern law permits a trustee to delegate certain duties if it would be unreasonable to expect the trustee to perform such functions themselves.
Like hiring an investment manager.
Exactly. Complex investment decisions, tax preparation, specialized real estate management. However, if a trustee delegates, they still have a duty to oversee the completion of that delegated task, selecting the agent carefully and periodically reviewing their performance.
So they can't just delegate and forget.
Absolutely not. And crucially, critical discretionary functions concerning trust distributions or fundamental policy are generally non-delegable. Also, a trustee with special skills like an attorney, investment advisor, or accountant, such as Sterling Bank and Trust might employ, is held to a heightened standard.
Higher standard for pros.
Yes, they must use those skills while serving as a trustee. They are expected to perform at a higher level than an average lay trustee.
That makes perfect sense. You wouldn't expect a regular person to be an investment guru, but if a professional firm like Sterling Bank and Trust holds itself out as one, they're held to that professional standard. What about how trustees handle the investments themselves? This seems like where most of the money is managed and potentially where things can go wrong.
This is indeed a major part of the duty of prudence. Trust investments under the Prudent Investor Standard, now often guided by the Uniform Prudent Investor Act, UPIA. The trustee must act as a prudent investor would when investing their own property, exercising reasonable care, caution, and skill.
Prudent investor. Okay.
And a key modern concept is that a trustee's investments are assessed by looking at the total performance of the trust's entire portfolio, known as the portfolio approach, rather than focusing on individual investments in isolation.
So it's the whole picture, not just one stock tanking.
Right. This is a huge shift from older rules that might have focused only on specific safe investments. Factors considered include the trust's distribution requirements, economic conditions, the specific investment's role within the overall portfolio, and the trust's need for liquidity, regular income, and the preservation or appreciation of capital.
So they can take on more risk in one investment if the overall portfolio balances it out, rather than every single asset needing to be super low risk.
Yeah.
That gives them much more flexibility, doesn't it?
Potentially, yes, if it fits within the overall diversified strategy for the trust and aligns with the trust's objectives. Key duties here include the duty to diversify assets.
Don't put all eggs in one basket.
Pretty much. The trustee must adequately diversify trust investments to spread the risk of loss, unless the administrative costs of diversification would outweigh the benefits. Also, the duty to make property productive.
Make it work for the beneficiaries.
Exactly. The trustee must actively pursue claims owed to the trust, derive the maximum reasonable income from investments, sell unproductive assets when appropriate, secure adequate insurance on trust property, pay expenses, and generally act within a reasonable time in all matters. This isn't just about chasing high returns, it means actively managing.
Not letting things slide.
Right. Not letting a valuable property sit empty, or neglecting to pursue a debt owed to the trust, or holding on to an investment that's clearly no longer serving the trust's purpose, and critically, the duty to be impartial
Impartial between...
between different beneficiaries. A trustee must be impartial, but this doesn't mean treating each beneficiary identically. Instead, it means remaining uninfluenced by favoritism or animosity and balancing the often conflicting interests of present beneficiaries, who typically receive current income, with future beneficiaries, the remainder men who are entitled to the principal later.
Income now versus principal later. That sounds like a tough balancing act.
It is. This means investing property, so it produces a reasonable income while preserving and growing the principal. Here's a common scenario for analysis on exams. If a fact pattern indicates that the trust principal is appreciating rapidly but not generating reasonable current income, or conversely, producing high income but the principal is depreciating,
Then something's wrong.
it's a red flag. Your analysis should immediately center on the duty of impartiality. This often signals that the trustee may be favoring one class of beneficiaries, for example, income beneficiaries, over another, example, principal beneficiaries, and breaching their duty.
That's a great red flag to look for. What about keeping beneficiaries informed? Transparency seems absolutely vital for such a relationship built on, well, trust.
It absolutely is, and a cornerstone of fiduciary duty. A trustee has a duty to inform and account. This means disclosing complete and accurate information about the nature and extent of the trust property, allowing beneficiaries reasonable access to trust records and accounts.
They have to show their work.
Pretty much. They also must provide notice to beneficiaries if they intend to sell a significant portion of trust assets